Part 2, the amended trust 2019, case number RP 221-20163, Alameda County Superior Court. Amended trust August 26, 2019, allegedly created in the midst of multiple pre-death hospitalizations for acute hepatic encephalopathy, brain edema, hepatic renal syndrome, etc. The latter trust, allegedly drafted by Attorney Rogers, changed the distribution entirely under the amended version. Each sibling was to receive $30,000 each, payable within 9 months, with 10% yearly interest and mandatory lien on the property if unpaid. The daughters were entitled to only 50.1% of the brothers' half of the house, not the entire half, and only if the financial disbursements to the siblings were met in full. None of these conditions were ever fulfilled, and no liens were ever recorded. The trustee simply ignored the trust's amendments. Trustees' transfer of the entire property in direct violation of both trusts. Despite the clear limits in both trust documents, the trustee transferred 100% of the brothers' half of the property to the daughters, who were entitled to only 50.1%. The transfer was contrary to the trust, contrary to the settlement agreement mentioned in both trusts, contrary to fiduciary duty, and destructive to the siblings' 24.9% vested beneficial interest. The property was valuable, making this one of the most severe breaches possible. Attorney William John Rogers has received at least $57,000 in attorney's fees, whereas the elderly beneficiaries have received nothing except small emergency food stipends 6 years ago in 2020. Evidence of title irregularities, false grant deed, hidden payment terms. The user possesses a grant deed showing Trustee Ferris signed under penalty of perjury that the transfer was made for no consideration. Attorney Briar Horn recorded the deed. His signature appears on the filing as the filing party. Yet, the 12-page settlement agreement in the probate file, signed by Trustee Ferris, William John Rogers, and Briar Horn, as well as the two daughters, proves the daughters were required to pay a sum of money, $82,700, in exchange for receiving the deed for 1810 Grant Street, the entire half of the house. Now that's a valuable house. This renders the recorded deed a false document, misrepresentation of consideration, and a basis for real estate fraud under California law. Filing a deed with false statements as a potential violation